there is zero empirical evidence that just because you got a +2, +3, or +4 as part of a conspiracy, and you otherwise are eligible for the 0-point offender, that your risk of recidivism is any higher than any other 0-point offender.
Right.
There's
right.
zero, and they cite to none.
Right.
But that was the whole point of the 0-point offender adjustment.
Right.
Was it was supposed to be empirically based,
Yeah.
data-based.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey, everybody. Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. So excited to be here. This is going to be the first episode of Set for Sentencing in 2024. And there's no other human on the planet that I would want to kick this year off with other than my good friend and colleague, Mark Allenbaugh. How are you, man? Happy New Year.
Happy New Year, Doug, and to everybody out there, Xin Nian Kuai Le.
That
Happy
is
New Year in Mandarin.
In Mandarin. This is one of the many reasons I love Mark Allenbaugh. He's a man of many talents. So what we're doing here today, I think the title is New Year, New Guidelines. So what else are we going to be talking about besides sentencing guidelines, right? But we're gonna talk about a couple of the new ones that went into effect and how they're sort of playing out, and then we're going to talk about the fact that the Sentencing Commission met towards the end of last year in November. I think I've been taking a little break, a well-earned break.
Yes.
So we haven't had time to talk about what some of the really important proposed amendments are going to be discussed, dealt with in 2024 that are going to be very, very important and meaningful to us and our people. And yes. I also thought that since it is the new year and then it's new year, new guidelines, that we need to just talk about our resolutions, our goals, our big dreams for the year and beyond, and what we have in store for ourselves, for our profession, for our personally, whatever. Mm-hmm. So we're going to pepper those through the episode too. It's going to be special. Oh, so special.
And this is a special new year because in the Chinese zodiac, starting in February, which is when the Chinese New Year is, this will be the year of the dragon, which is the symbol of wisdom and many culturally interesting things. And it's a really good sign to be in 2024 in the year of the dragon.
Yes. Wow. Okay.
Yeah.
Well, that's
part also of the Qing dynasty, which is near and dear to my heart, because I used to live up in Manchuria, which is where the Qings were from, Qing, up in northeastern China. Manchuria is probably most people know it as.
I am surprised that the dragon is a symbol of wisdom. I would have thought other things like fury or fire or
that's the European dragon, because Westerners, we're really violent people. But the Chinese, they're very wise people. So
okay, well, I've been watching too much Game of Thrones and House of the Dragon, so
there you go. That's all that's all Western mythology. So
exactly.
And today we're going to talk about sentencing mythology. So that's
right. Well, we need a little wisdom in the sentencing process, so let's hold on. A ton. Let's hold on to that dragon. Yes. Let's ride that dragon.
Very good.
Wait, isn't that what they called smoking opium, like riding the dragon or something like that?
Oh yeah, but I don't know whether I don't know if that derived. I don't know if that was derived from the Chinese or from the British, who were the drug dealers at the time.
Well, so I say we ride for whatever it's worth. Let's ride the dragon.
Ride the dragon.
Speaking of riding the dragon, of course I have tequila. It's because it's it's actually New Year's Eve tonight,
It
so
is New Year's Eve. Yes,
I
yes.
figure there's no better time. And I'm not going to give a big spiel about what I'm drinking today because I did a whole 13-minute YouTube episode just for the fun of it like a week ago when I got this new bottle called Don Rico.
Oh,
But did I tell you about this guy?
no.
He's a lawyer.
Uh-huh.
He's a lawyer from Texas. He represented some big tequila brands and he fell in love with tequila and he started his own brand.
Yeah.
His name's Rick Avila, I think. And anyway, I got this bottle gifted to me when I was
Nice.
presenting in New Mexico, and it's actually a phenomenal bottle of tequila. I'm madly in love with it. So,
Well, speaking of drugs, I'm drinking. You may have heard of this drink. It's from Atlanta, Georgia, known as Coca-Cola.
oh,
Yeah. So
interesting.
yeah, going
So
hardcore here.
you're doing a little Coke today. That's
Yeah, there you
good.
go.
Good.
To
So
match your tequila.
we got a little tequila, little
Yes.
Coca-Cola, and let's ride the dragon. So
That's right,
let's
the
talk
dragon.
before we get to the stuff that's maybe in store for us this year. Let's talk about the some of the big changes here from last year.
Right.
Is that where
Right.
we want to start?
Yeah, I think that's where we want to start. So I'm going to share my screen here.
Yeah. We know that the 0 point offender thing was made retroactive, and the big
Right.
date to look at is February 1, because that's when it
Right.
goes
And
into
we've
effect.
discussed the 0 point offender. So today, there were a number of amendments that went into effect on November 1. And one of the bigger ones that's received a lot of attention, of course, was the 0 point offender, as well
Yeah.
as the status points which had to do with criminal history. But I thought that we would highlight a couple of other amendments that went into effect on November 1 that not many people are aware of, because the 0 point offender and status points
Kind of
were
dominated.
when they dominated because they were made retroactive. So they were
Mm-hmm.
applied. So they're already they can be applied to everybody that's already in prison now.
Mm-hmm.
Now there was a bunch. These aren't the rest. These are just a few of the rest. But these are the ones, I think, these amendments that were not made retroactive, but these are still important amendments for counsel and for attorneys to be aware of going forward now. And one has to do with acceptance of responsibility, which applies in almost every case. Because as we know, about 97% on average, sometimes a little bit more, sometimes a little bit less, but around 97% of all federal defendants that are convicted as the result of a guilty plea,
Yeah.
whether it's an open plea or a plea pursuant to a plea agreement. But regardless, when somebody pleads guilty, they're entitled to an acceptance of responsibility downward adjustment of 3 levels if their total offense level prior to the application of the acceptance of responsibility adjustment is 16 or more. They
Yeah.
can get 3 off. If it's less than 16, and what this means, by the way, for the listeners, you take chapter 2 adjustments, chapter 3 adjustments, add them all up, and if they are 16 or more and you've pled guilty, then you can get at least 2 levels off
Right.
for acceptance of responsibility. And if the government so moves, you can get a 3rd level off. And that's what we're going to talk about, is that 3rd level. And just for completeness sake, if your chapter 2 and chapter 3 adjustments prior to acceptance are below 16 or less than 16 offense levels, you're only eligible for up to 2 levels off for acceptance of responsibility. So this new amendment that I'm going to talk about here in a minute, which went to effect on November 1, applies specifically to what's called the 3rd point.
Yeah.
And those are the individuals, again, that their total offense level prior to application of acceptance of responsibility were 16 levels or more. So we know that they're immediately eligible for the 2 levels off for acceptance. And so the commission has always had this 3rd level. And the 3rd level, though the court could not give automatically, this was up to the government to move the court to give that third level. And the third level was basically about, how much trial preparation did the government have to do, or how, let me put it this way, how timely and how early was that acceptance of responsibility? How early did the defendant plead guilty? If the defendant pled guilty early enough in the prosecution process, then the government would move for that third level, and almost always the court gives it. But a split in the circuits had developed about what early meant. And in some circuits, early meant you plead guilty, you do not bring any pre-trial motions, such as a motion to dismiss, for example. That would be the big one. Motion to dismiss based on, Fourth Amendment grounds or something along those lines. And in other circuits, they said, no, this has to do with acceptance of responsibility, or this has to do with not just acceptance of responsibility, but how much trial prep the government had to do, as opposed to pre-trial litigation. And what the commission did here is they made clear it was that pre-trial litigation does not preclude a defendant from receiving that third point. So in other words, if the defendant moves to dismiss the case, or dismiss the indictment, excuse me, or other pre-trial litigation, again, this is pre-trial, this isn't trial prep or when he's at trial, because as we know, once you go to trial, almost always you're precluded from getting acceptance if you have to put the government to its burden of proof. But this has to do with pre-trial litigation. And so what the commission said, and this is, I'm showing the changed language or the added language here to acceptance of responsibility, is now pre-trial litigation, such as moving to dismiss, does not preclude the government from moving for that third level. So that's why they have this term here, preparing for trial. They define that, and this is all added now at 3E 1.1. Preparing for trial means substance. So what this new language is meant to apply when the government seeks to not move for that third level, or the government moves for that third level and the court considers it and decides not to grant that third level. So in short, you're not eligible for that third level if the government had to engage in preparing for trial. And what does that mean? It means substantive preparations taken to present the government's case against the defendant to a jury at trial. Preparing for trial, or I'm reading this, by the way, for your listeners that may not be watching this on YouTube. Preparing for trial is ordinarily indicated by actions taken close to trial, such as preparing witnesses for trial, in limine motions, where you're trying to exclude evidence, proposed voir dire questions, and jury instructions, and witnesses and exhibit lists.
Am I right in reading this that the big change was it used to be that the government had the power, they had to move for that third point, but is it right to read this now as you basically are presumed to get 3 unless the government moves against that extra point and makes a compelling case that they had to do substantial trial prep?
Well, it's more that latter point that you're making, that now the only way the government really can object to that, I'll put it this way, the government always has to move for that third point unless they engaged in trial preparation as defined here, actual trial preparation. And that's what I was getting to. So where the commission says here, preparations for pre-trial proceedings, such as litigation related to a charging document like an indictment, discovery motions, and suppression motions, Fourth Amendment stuff, ordinarily are not considered preparing for trial under the subsection. So now your pretrial litigation, you want to dismiss the indictment, like a child pornography case. You move to dismiss the indictment on Fourth Amendment grounds. In many circuits, that would preclude you from getting that third level for acceptance because the government wouldn't move for it. And
Mhm.
your counsel could object to that and say the court, hey, this is bad faith. The government should be moving for it, and the court wouldn't grant it anyway because the court would say, well, they're having to do any litigation. Having to engage in any litigation would preclude that third point.
Yeah.
And so now what the commission has made clear is no, it has to be litigation regarding trial prep, not the
Yeah.
pretrial stuff.
Yeah.
So now you're still
Right.
eligible, and the government should move. And if the government does not move, it is very important for counsel to raise this issue and raise this amendment to the courts so they understand that this third level should be granted. So even if the court is limited by the government's motion, so the court couldn't grant that third level without the government motion, but what it can do is vary downward by at least one level if the government is just being ridiculous and won't move for it because they had engaged in some discovery stuff. So now the way I read this, again, and the commission can't force the government to bring these third levels, but what this does do is give ammunition to defense counsel to explain to the court that the level is still appropriate and should be given. If the government doesn't move, then vary by at least one level.
Okay.
Yeah. Does
All
that make
right.
sense?
Well, that does. Yeah. And I'm looking at the language still in there that upon motion of the government
Right.
stating, which stupid. It's
Right,
like,
but that's the
I mean,
variance though. So
I
yes,
know.
upon motion for the government, and if the government doesn't move,
Yeah.
then your honor, look at this stuff.
Sure.
The commission clearly believes that the government should move for it in this
Yes.
situation. This was all
Sure.
pretrial litigation, so vary downward by one level because they're being ridiculous.
I'm just having sour grapes because the government shouldn't have a fucking say in the matter is what I'm saying. You either get acceptance or you don't, and the fact that we have to rely on them to make the motion still irks me. But the good news is they're limited in how why they can object to it, which is real trial preparation, and that is a big deal.
Right.
And I don't want to give that short shrift because what people need to understand, and I know we've talked about this in the past, but a lot of lawyers maybe take a timid approach to say, well, if we fight this too hard, if we file this motion, if we challenge this, if we do a motion to suppress and lose, we may not get a good deal. We may lose a third point of acceptance. And the answer is no, you can't lose your third point because of that. And those types of aggressive challenges, if they're not frivolous, are what can result in give you leverage in plea negotiations. They can result in a better plea offer. Right. And so, and
it might make the government look ridiculous if they're not going to move for the motion. Argue for the variance and give the court this language.
Yeah. Absolutely. Yeah. And litigate the shit out of your cases pre-trial.
Exactly. So that's the other intention. That's the other intention behind this amendment that the commission wanted, is so defendants were not afraid to litigate sometimes always, of course, legitimate issues regarding discovery issues, Fourth Amendment search and seizure issues, etc.
Right. And think about how messed up that is. You get charged with a crime. The police looks like they violated the Fourth Amendment, or they extracted an illegal confession out of you, or they did an illegal search. They broke the law, the highest law of the land, but yet you're afraid to challenge that because if you don't roll over and play dead and accept a plea with giving up no fight at all, then life's going to be more miserable for you in our system. And that is the way our system tends to work. And this little 1-point deal has helped the prosecutors facilitate that injustice for 20 plus years since the guidelines have been in effect. So I guess I'm happy that 30 plus years. Thank you. I'm happy that this little change has been made, and I'm glad you're pointing it out because it is something that should not be overlooked, should be on everybody's radar, and hopefully it will be moving forward. And that thing went into effect on November 1st, 2023. So that is the guideline. That's a done deal. Okay.
Done deal.
Good. What else do we need to talk about in terms of done deals?
Okay, so done deal number 2, which is really big, has to do with the safety valve. And this is at 5C 1.2. And so what the safety valve is, this applies exclusively to drug defendants that are looking at a mandatory minimum.
Yeah.
And as we know, judges are precluded from sentencing below a mandatory minimum, hence the term mandatory, except in one situation. And that has to do with the safety valve, which was created by Congress. And it's set forth at 18 USC 3553F, like Frank. And there is set forth several criteria that if your client, the defendant, meets these criteria, then the court is allowed to sentence below that guideline, or below the mandatory minimum, excuse me. And generally, the court will want to do that when the sentencing guideline is below the mandatory minimum.
Yes.
And that happens rather frequently.
Yeah.
So
judges, by and large, are not big fans, in my experience, of mandatory minimums. If you can give them a reason to get under it.
Right. And because
thing.
they take away their discretion, and mandatory minimums have always been a thorn in the side of the philosophy of the sentencing guidelines, and a thorn in the side of the Sentencing Commission.
Yeah.
Because the Congress gave the authority and discretion to the Sentencing Commission to draft up and create these guidelines, but then took some of it away with respect to mainly, but not exclusively, but mainly drug cases where they created mandatory minimums. Another place, by the way, where we see mandatory minimums are in like child pornography cases, but the safety valve does not apply to those cases. And also aggravated identity theft, which is where you generally are fraud cases. Those cases also, the safety valve does not apply to. So again, this is exclusively to drug cases where the commission or the government, or excuse me, Congress created certain criteria where the defendant can be sentenced below the otherwise applicable mandatory minimum. And really, so what kind of defendants are these? They're generally your mules. They're not high level. They don't have management level authority within the drug conspiracy. They're just the ones that are driving the drugs, excuse me, across the border or across town or across state or something like that. But they're not involved in the higher level mechanics of the drug conspiracy or the trade. So getting down to nuts and bolts, one of the big changes had to do with the criminal history points. And I'm so glad that the commission, as of late, has been looking at criminal history and looking to see if it has been treating defendants in an overly severe fashion. And obviously, the commission has decided that's the case. Hence, the Zippo 0-point offender adjustment and the status points adjustment. Here, traditionally, you were only eligible for the safety valve, which meant you could be sentenced below the applicable mandatory minimum if you had no more than one criminal history point.
Yeah.
Now the commission has opened that up to 4 or more criminal history points. So that means you could be up to criminal history category 3 in theory, and still be eligible for the safety valve.
You just have to make sure that that's on your radar. Anyway, moving on. Well, let's take a break. I want to talk about it's New Year's resolutions. Do you have any personal or professional? New year, new guidelines, new.
Well, professional. Professional. I would say I'd like to publish a few more articles with you. And
that's sweet.
And something that's impactful and maybe cited by the Supreme Court when they decide that acquitted conduct is unconstitutional, and they take that issue up, and they say something about uncharged conduct as well, and the constitutionality of that. I'm tired. It's New Year's Eve.
I hope you're getting a nap before the festivities start.
Yes, geez, I think I'm going to. And I guess personal, I'd like to leg press 1,000 pounds this year. Get it up there. Yeah.
What? Wow. Where are we now? Like, how many pounds?
893.
Wow.
Yeah. I
That's
blew my pec out, so I can't bench anymore and intimidate my daughter's boyfriends, but at least I can do that in the leg press.
Did you ever see the movie Clueless? I always
Oh, years
with,
ago,
with
yes.
yeah, with well, there's a great line in there. I don't have daughters, but if I did, I would have loved to use this line when the guy comes over to take his daughter out. He says, "I have a gun and a shovel, and I doubt anyone would miss you."
Yeah, I'm that guy. I'm that guy. I'm that guy. I also have a German Shepherd, and he doesn't
Oh.
like either of them.
Well, that's a lovely those are lovely resolutions, and
Yeah.
I'm flattered you want to write more articles. I would gladly, happily take you up on that.
Okay.
That's one of my resolutions too. I got to start writing a little bit more.
Yeah.
I wasn't super prolific in my written work last year. I think I published a couple of things, but what I'm really working on now is I just submitted my book proposal
Oh, you're
on
right. Right.
for
Yeah.
sentencing for mitigation videos.
Yeah.
So, people know that's my jam, and it's something I've been doing for 20 years. And, I work with a lot of people who do this space, and we lament a
Yeah.
lot about how more and more people are starting to produce these videos, but they kind of sort of don't know what they're doing, and they're
Right.
not very good. And you kind of worry that the more people you love that this is becoming more prolific, and so many more people are introducing these into their cases because they're a super effective tool of advocacy, but you
Yes.
worry because if people are not doing it well, it kind of can spoil it for the rest of us. We don't want
Right.
to get judges soured on a few bad examples. So
Yeah.
I've been working for a lot of years just on various articles and chapters, and it's been in the works. And I said, this is the year. I'm going to publish this book, The Definitive Guide to Producing Mitigation Videos, not just for sentencing. We use them for plea negotiations. We use them for bail
Right.
hearings. We use them for post-conviction relief, clemency proceedings. I have three that are pending before the president right now in clemency, in capital clemency cases. So the point is, this is an amazing, powerful tool of advocacy, but it's got to be done right. There need to be some standards, some consistent standards. So
Right.
the NACDL, National Association of Criminal Defense Lawyers, has my proposal. If they don't accept it, that's okay. I will self-publish the book, but this is the year that book is coming out. It's been a long time in the making.
We need to get you on Rachel Maddow once that comes out. You got to
Ooh,
do, yeah.
I love me some Rachel.
Yes. Yeah. She
Get
would love
what?
this.
Get me on those fucking Fox shows too. I mean, listen,
No.
the-
Yeah.
these
No. Yeah.
these
Seriously.
issues of criminal justice. I mean, for better or for worse, that's one byproduct of the 1/6. Like all of a sudden, people are starting to pay attention to the fact that,
Yeah. I
oh,
think
I think
there might
maybe
be
things
some,
aren't always so fair in the federal
yeah, I
system.
think
Oh,
there might be some guy, I don't know, he used to be in the White House that might need you. I don't know. We'll see.
what would that sentencing video look like? Oh my goodness. Yeah.
What I'll tell you what, with not him talking.
Right. Right. Right.
Exactly. With not him
Yeah.
talking.
I'm
Yeah.
pretty sure A, that I won't be getting that call, and B, that if I did, that may be the first time in my professional life that I've been stumped about how I could advocate for a client, but who knows? So what were we doing? We were talking about legal shit.
So yeah,
So
oh, legal shit. Yes, back to legal shit. So proposed new amendments. Yeah, so back in
yes.
August, the sentencing, I think it was August, I can't remember exactly when, but in the last few months, the Sentencing Commission published its proposed new amendments to the guidelines.
Yeah.
And I have to say, as a whole, it was very underwhelming.
Yeah.
Their proposed amendments last year were very ambitious, covered many different areas. You and I have only spoken about a few of them, the ones at least that we think are most broadly applicable, but that doesn't mean they weren't necessarily the most
Yeah.
important or interesting.
Yeah.
But the commission did, I think, an excellent job after being in hibernation for so many years because they couldn't do anything prior to last year. because they didn't have a quorum. They didn't have enough commissioners. For whatever reason, Trump just let all the commissioner spots expire and didn't fill those empty positions. So the Biden administration luckily filled them very quickly, and we had a very robust and needed amendments to the guidelines, including those to compassionate release, which was really huge during the pandemic and still remains very relevant. And one of the big issues, and we spoke about that about the changes to compassionate release several times, I believe. But that's another big area, is the expansive criteria now for compassionate release under which defendants can seek it. But now this next amendment cycle, they started off with a bang, and now we're going into a whimper, and there's nothing really too exciting, but there's still some stuff there that's worth noting and paying attention to.
We got like the top 3 here to talk about,
right? We have the top, I think, the top 3, yes, or top, we have top 3. Yes.
So, and I know this wasn't first on your list, but I'm kind of excited because we've been talking about acquitted conduct for a while.
Yes.
And I will just say we've done 2 podcasts with Professor Doug Berman from the Ohio State University. The first,
I can't believe they lost to Missouri. Signs of the apocalypse. Anyway,
oh no, I didn't know that.
Yeah.
I'm spending time tonight at New Year's with a diehard OSU fan. I didn't know that they lost.
Don't bring it up. Don't bring it up.
Oh no. Okay.
Yes. Oh, by the way, my Trojans won. Just for the record, my Trojans won. We beat some school in Kentucky. I can't remember which it was in the Holiday Bowl. So
that's lovely.
That. Yeah, it is lovely.
And is it a point of pride that your team is named after a condom, or is it something you like to?
Because nothing breaks through the Trojan defense. Excellent. Which actually isn't true, because we had a shitty season.
Ah, boy. Well,
we didn't hold up our end of the bargain.
Is that why you're playing some unknown Kentucky school in some unknown bowl game?
Bingo.
Okay.
Yeah. You're very astute. Your powers of induction.
And I don't know from sports that much, although I did just go to my first Suns game with my buddy Mark Lerner. It's the first Suns game I've been to in probably 20 years. And I actually enjoyed it a little bit. It was very entertaining. Too many timeouts, and the popcorn was way too expensive. Acquitted conduct. We did episode 36 with you. We're on it, and Doug Berman. And then we revisited it in episode 65, where you guys had the smackdown, where you just like took off the gloves and did bare knuckle brawl. And so the point is, though, this has been on our radar for a long time, and it's a huge issue. And they were punting to the Supreme Court because there were all these cases pending. But it looks like they're finally ready to do something.
Well, don't jinx it.
They proposed.
They proposed before too.
Oh, they did, and then they punted.
Last amendment cycle, when they came out of the gate and all these great proposals came forward, acquitted conduct was one of them, and they took it all the way to the 11th hour. And they heard testimony on it, and they revised the proposal, and they actually had some amendments ready to go on acquitted conduct. And then they decided to punt at the last minute. And part of the reason was, well, there are all these cases pending. And I think it was upwards of 13 cases pending cert before the Supreme Court, all about acquitted conduct. And so they decided to punt, and let's see what the Supreme Court's going to do. And then the Supreme Court, on the last day of last year's session, said, oh, well, we heard that the commission's looking at this, so we're going to punt. We're going to deny cert in all these cases. But there was it was very interesting, because even though they denied cert in all these 13 pending cases, maybe more than 13, Sotomayor, Kavanaugh, Gorsuch, and Berman, Amy Jackson. Wait, and Berman, is there? Why am I blanking out? Amy
Amy Coney Barrett.
Barrett. I
Amy
say
Coney Barrett.
Berman.
Yes.
See, you said Professor Berman, and I
Berm.
got stuck in my little head.
And
I'm
there
gonna
is
have,
another Judge Berman. Yeah,
yes, out of
Jack.
DC. Yeah, down
You're
in
talking about
DC.
Amy Coney Barrett, or
I'm talking about
you're not
Amy
talking
Coney
about
Barrett.
Ketanji Brown Jackson. No.
No.
Okay.
Although I think she may have written something too. But at any rate, at least four of them wrote a statements respecting the denial. Oh, and so did Alito. He also wrote a statement respecting the denial of cert. And all of the issues, what they all pointed out was, well, let's see what the commission does. But they also made some really interesting observations, including Alito, that it really doesn't matter what the commission does. We really should take this up because
Right.
it's a constitutional issue
Right.
rather than just a guidelines issue. But nonetheless, at the end of the day, they punted, took none of the cases, and the commission, once again, and good, and to its credit, has taken up acquitted conduct. And what it is proposing.
And just to refresh for people who
Yeah,
haven't
let's refresh
all these,
yeah.
This is a really messed up area of federal criminal law, which says you could go to trial and be acquitted by a jury, and then later on get in some other trouble, and it's time for sentencing, and they can bring back that thing that a jury found you not guilty of and use it to enhance your sentence. That's what we're talking about when we talk about acquitted conduct.
Yes, that's one scenario that it could work against you, where a subsequent you're brought to trial on wire fraud, one count of wire fraud, you're acquitted. 3 years later, you're brought to trial on another count of wire fraud, completely unrelated. The court can still now take your acquitted conduct into consideration on that subsequent one. I think that was the scenario you were pointing out.
Yeah.
But the other scenario too is you're brought to trial on 2 counts of bank fraud. You're acquitted on one and convicted on the other. Both those come in, both the loss amounts come in at sentencing.
Yeah.
So the acquittal doesn't really matter.
As if that acquittal never happened. Yeah.
Exactly. It's irrelevant.
Yeah.
It's irrelevant. So this has been another thorn in the side of the commission and the sentencing guidelines since the mid-90s. And obviously the issue is, if I'm acquitted of something, how does it pass constitutional muster? How does it pass due process at the very least, if not Sixth Amendment notice that I can be sentenced for something I've been acquitted of? This has been an issue that has been festering for a long time. And the commission has once again decided to take a look at it. And that's what we have up on the screen here, is what the commission plans to do. It's basically, there's 3 options. The first option, frankly, I won't go through all 3 of them, but the first option is probably the most viable, and that's basically says that acquitted conduct is not relevant conduct. Which what does that mean? That means that a court cannot use it to enhance a sentence. If you've been acquitted of $1 million fraud, the court cannot, and you've been convicted of say you can be convicted of a $2 million fraud and acquitted of $1 million fraud. What that means is that the court cannot sentence you as if you committed a $3 million fraud, which it can do as of now. But if this amendment were to pass, then under the guidelines, at least, the court cannot sentence you, cannot calculate the guideline range as if you had committed a $3 million fraud. But what that does not preclude, and the problem with this that Alito pointed out in his dissent from denial of cert last term, was that this does not address the constitutional issue, because judges could still upwardly vary or upwardly depart. They can still consider that acquitted conduct for the ultimate sentence. They may not consider it for application of the guidelines, but it can still influence them. And the point ultimately really needs to be addressed by the Supreme Court. This is really just window dressing, and it's only going to cause confusion. The Supreme Court can address the constitutionality of the use of acquitted conduct to say, look, it is unconstitutional to use this for any purpose, whether it's an upward departure or an upward variance or calculating the guidelines. It doesn't exist. It's not like it's not relevant conduct. This shit is innocent conduct.
Right.
You cannot punish somebody for innocent conduct.
Right.
End of story. And that's what the presumption of innocence is all about. So one of the things that we spoke about, and forgive me, I'm almost out of air, so I'll stop in a second. In addition to the implication that this has for acquitted conduct is uncharged conduct.
Yeah.
And this is not something that Mark Allenbaugh has come up with, by the way. This is something that the U.S. government itself conceded in several briefs last term. And what did it concede? It conceded that if acquitted conduct, the use of acquitted conduct is unconstitutional, then so is the use of uncharged conduct. The government conceded. And this is where, Professor Berman and I went fisticuffs.
Right.
We went to fisticuffs on this. But of course, I'm right. Excuse me, Professor Berman, but but I'm right on this. It's not me, frankly. I'm just agreeing with the government because the government itself conceded in multiple briefs that if acquitted conduct is unconstitutional, the use of acquitted conduct is unconstitutional. So is the use of uncharged conduct. Oh, what? Yes, Justice Alito conceded that as not conceded. He stated it right out in his dissent too, that acquitted conduct and uncharged conduct, they rise and fall together. Right. And so why is that significant? Because all relevant conduct, not all of it, but most of it is uncharged conduct. And it's uncharged conduct that drives the guidelines.
Yes.
So a big example, by the way, is the loss amount in a fraud case. You never charge loss, what the loss amount is. Why? Because it's not an element of wire fraud or bank fraud. It's not. In some states, under some state statutes, the amount is whether it constitutes an aggravated felony or a regular felony or what have you. But who cares? We're talking the feds here, and at the federal level, the amount of loss doesn't matter. The amount of drugs doesn't matter except for the mandatory minimum. And the Supreme Court addressed that a while back. I can't remember the name of the case, but addressed that a while back and said that, look, if you want to charge or hold a defendant to a mandatory minimum, you must charge the triggering amount to get that mandatory minimum.
Yeah.
But so setting all that aside, though, the uncharged conduct, which isn't just the loss, which isn't just the drug amount, which could also be stuff like role in the offense, which could be stuff like the sophisticated means and all these other all these other sentencing factors. All of those potentially now are unconstitutional unless charged and found by reasonable doubt by a jury or stipulated to in a plea agreement by a defendant. So this potentially could be earth-shattering. Not what the commission does. What if the commission says acquitted conduct can't be used to calculate the guidelines? It's really not going to be that earth-shattering because we know so few cases. First of all, so few cases go to trial, less than 3%, and only a tiny fraction of those 3% results in a combination of a conviction and an acquittal. I think it was something like 80 back in 2022 out of the nearly 60,000 federal cases. So we're talking an infinitesimal amount that this amendment would directly affect. But the bigger issue is if the Supreme Court now sees what the commission does and say, okay, now we see what the commission has done. Now we know where to step in. Now we know where to carve out the rest of the universe. They've started, and now we can complete it. And if they do the right thing, they'll take cert on one of these cases, and they will complete it the way Justice Scalia wanted it completed, Justice Breyer wanted it complete, not Breyer, excuse me, Kennedy, and Ginsburg and Thomas, and by the way, also Justice Gorsuch and Justice Kavanaugh, both are on record from when they were on the appellate court that they believed that the use of acquitted conduct was unconstitutional. And Kavanaugh went this additional step and said that uncharged conduct also was unconstitutional.
Yeah.
Boom, boom. So that's what I want for Christmas. That's what I want for the New Year. That's my New Year's wish. If I could, if I was king of the world, I would resolve that the
that would be a
sentencing commission do this. Yes,
seismic shift, because
and it's going to happen. And I know it's going to happen.
All the bad things that happen with the guidelines are usually as a result of something in that orbit.
Yes.
So,
yes.
So we had three big things to talk about: proposed amendments. We did acquitted conduct. Now let's talk about intended loss.
Yes. So intended loss, traditionally, as we know under the guidelines, loss is the main driver of the fraud guideline under 2B1.1.
Right.
And loss has always been defined in the commentary, not in the guideline itself, but in the commentary to the guideline, as the greater of intended loss and actual loss. And actual loss means what it says, actual loss. And intended loss is basically where I solicit Doug Passon for $1 million investment in my fictitious cryptocurrency. And it doesn't exist. But he never invests. He never invests with me. He never sends me the money. But the fact that I solicited him this cryptocurrency did not exist is fraud. And so that would constitute intended loss. I intended to defraud Doug Passon of $1 million. And let me put it this way.
But Doug Passon is way too smart to fall for something like that.
Way too smart, because he follows the sentencing podcast, and he's up to date on all this crap. So he knows, don't invest cryptocurrency,
especially in crypto.
Especially in crypto. So at any rate, so that's intended loss. It doesn't mean actual loss. If Doug had sent me $1 million and then I went out on a Caribbean cruise for a year, then that would be actual loss. I didn't put it in crypto or anything like that. So what happened was a few years ago in 2019, the Supreme Court issued a decision that had nothing to do with the guidelines directly. Kisor, K-I-S-O-R versus Wilkie, W-I-L-K-E. And Kisor versus Wilkie, it was an administrative decision. It had to do it with administrative law. And what the Supreme Court there said was, if an agency's definition or commentary about its regulations are not binding on a court, not only are they not binding, they may not be followed unless the agency's regulation itself is genuinely ambiguous.
Mm-hmm.
So a court is only to defer to an agency's commentary or explanation of its regulation if and only if the agency's regulation is genuinely ambiguous. And this is going a little bit far afield for those who don't practice outside of criminal law, but this has to do with a case that the Supreme Court is now addressing, an case, a foundational case in administrative law that has to do with the it's called the Chevron doctrine, and that has to do with how much deference a federal court is to give an agency's interpretation of its own regulation. And so the Supreme Court now has narrowed the Chevron doctrine in Kisor versus Wilkie, where before you were to defer to the agency's regulation if it didn't matter if it was genuinely ambiguous or not, as long as the agency's regulation was a reasonable interpretation, or the agency's commentary about the regulation, as long as it was reasonable, then you defer to that.
Right.
But what the Supreme Court said in Kisor versus Wilkie is they constricted that, said, no, we got to go a bit further here. You only defer to it if the regulation is genuinely ambiguous. And by the way, this term, they may overturn that doctrine altogether, which means there's going to be no deference at all. But kind of jumping ahead, as it stands right now, Kisor versus Wilkie, you only defer to an agency's commentary or interpretation of its regulations if the regulation is genuinely ambiguous. So what happened from that? What does this have to do with the guidelines? So the Sentencing Commission is an agency like any other agency. It's a unique agency. It's in a judicial branch. It's a weird agency.
Backing up, like what it's all of narrative is problem solving. What was the problem? The problem was Kisor. We were able to take Kisor and say, look, this language is in the commentary, and use that to say intended loss is not a thing anymore. It's actual loss because that's what the guideline says.
Well, so the argument was, which is what the Third Circuit found in United States versus Banks, they looked at 2B 1.1, and the word loss occurs in there. And what they found correctly, in my opinion, is loss, the term loss as it's used in 2B 1.1 is not genuinely ambiguous. And then they went out and looked at a bunch of dictionaries, and no dictionary defines loss as intended loss. It's something you actually lose.
You lose, yes.
Yeah, it's actual loss. And so applying Kisor, because loss was not genuinely ambiguous, they said we can't defer to the commentary now, where the commentary says it's the greater of intended or actual. So it can only be actual. And that's great for many defendants. It's very defendant friendly, because usually that's what the government wants to do in these attempted cases, and is to jack up the loss guideline, the loss amount through intended loss, even though there may have been no actual loss. They just go for intended loss. And so now in the Third Circuit said you can't do that. There was a split developed. The Sixth Circuit, and I think maybe one other circuit looking at this, but at least one other, I know for a fact the Sixth Circuit went the other way, and the Sixth Circuit said that loss is a genuinely ambiguous term, so therefore we can defer to the commentary. And so when we look at the commentary, it says loss is the greater of intended or actual, so it's okay to use intended because loss is ambiguous. So now what the commission, so the issue going back to Kisor was, remember, it's the difference between what the regulation, or in this case the guideline, says. Is the guideline genuinely ambiguous? If it is, then you can't go down to the commentary. But if it isn't genuinely ambiguous, then the commentary is okay. So the commission is trying to do an end run here, and I think this is stupid as a policy perspective. It makes perfect sense for what they're going to try here, but I think it is an awful policy decision. What they are saying now, what they're trying to do, is move the commentary about what loss means into the guideline itself. They want to move the definition of loss as being the greater of intended or actual loss into the guideline itself. The reason why I think that's stupid is now they're going to have to do that across the board. They're going to have to basically rearrange the guidelines wholesale and basically get rid of the commentary. If they really want the commentary to have oomph to actually be followed, and to avoid all the litigation about whether terms in a particular guideline are ambiguous or not, then they need to move everything into the guideline itself. And that's just that's really it's a silly way for a fix without any policy designation. Why keep intended loss? The intended loss is a completely different measure than actual loss. Intended loss isn't a measure of the harm the offense caused, because as we discussed, I mean, I might solicit you for $1 million, but you never paid it to me.
Right.
So what actual harm is there? None. What intended loss is a measure of is of my culpability. It's a measure of the defendant's culpability, whereas actual loss is not a measure of the defendant's culpability. It's a measure of what the offense caused, of what the offense actually caused. So there's two dimensions of difference here.
Sure.
And these are, I mean, this isn't even apples and oranges. It's like
Well, and not for nothing,
So
the intent is such an ethereal concept too, because
exactly too. Yeah.
what if you solicited me for the $1,000,000, but it was such a ridiculous submission on its face that no reasonable person would ever fall
Right.
for this fraud. And so the risk of harm of this actually causing damage is virtually non-existent.
Right.
Yes, it's still fraud, but who cares? I mean,
Right. So
you
so and
know,
that's a very good point, Doug, because what happens is in intended loss cases, and I only know this anecdotally as opposed to empirically, and I'll explain why in a second. But I know anecdotally that in high loss cases that are based on intended loss, courts vary downward significantly
yeah,
because they know this is BS.
it's pure
If
speculation
it's pure
oftentimes.
speculation. I could be a nut and solicit you for $1 billion. I mean, I know you do really well, but I know I'm tell me if I'm wrong, you may not have $1 billion in liquidity, so
No,
but under
I'd
the
have to liquidate a lot, all
you
my
have to liquidate a
yeah.
lot. So,
Well,
it's
I
not
just had is another just to give you a concrete example. Just worked on a campaign finance case where it
yes,
involved us allegedly fraudulent email solicitation where we all get these donate to a campaign and you have a
right,
box donate $5, donate $10, donate 15 or other, and so the email is sent, let's just say, to 1 million people. And the
right.
government wanted to say the intended loss was if 1 million people gave like a
Totally
thousand
speculative.
dollars,
Yeah, right,
and so they literally had the loss in the millions when the actual loss was about $70,000.
right, right.
And
Totally speculative.
my answer to that is under that ridiculous government theory,
Yeah,
preposterous, asinine government
right,
fuckery. The intended loss is all the money in the world because there's another box. So
right,
presumably, if I send out 1 million emails, I really want people to donate all the money they have in the world by checking
right,
the box. So really, I'd hope that I get $1 billion for every email that I send
right.
out.
Exactly, exactly. There's no principal limitation to what could constitute intended
Yes.
loss. So at any rate, so my point simply is this, that the in anecdotally, I know that the courts sentence below the guideline range or very below the guidelines range significantly in intended loss cases, and they still they still vary below in actual loss cases, but not as much. But here's the problem why I only know this anecdotally as opposed to empirically, and I'm Mr. Empiricism when it comes to sentencing, is because the Sentencing Commission does not classify whether the loss amount was intended or actual or a combination of both. So the commission itself is flying blind on the effect and how courts are treating intended loss versus actual loss. So it is frankly recklessly ignorant for the commission to keep this equivocation going
Yeah.
between intended loss and actual loss when we know, at least anecdotally, and the commission hasn't investigated this that intended loss is treated significantly differently at sentencing than actual loss. And the reason is very apparent because it measures something very different than actual loss. It's the defendant's culpability, and it's a poor measure of that. Whereas actual loss is a slightly better measure, but of something completely different, the harm actually caused by the offense. So at any rate, what the commission is trying to do here, it's a bad Band-Aid on it's a fix. Actually, I don't even think it's a bad Band-Aid. This is it's a cure worse than the disease because it's going to lead to all sorts of drafting chaos in the future about the guidelines, about what should go into the guideline itself, as
Yeah.
opposed to what should be commentary. And there may be some legitimate reasons for some commentary to be moved
Yeah.
into the guidelines. There may be some legitimate reasons. I can't think of any off the top of my head, but I'm willing to say, like, there might be some legitimate ones, but this is not a good one. This is a bad one, and
So
it's going to set terrible precedent.
if we're doing New Year's cheers and jeers,
Yes.
This is a jeer.
This is a jeer. This is a total
Oh,
jeer.
and I
Acquitted
think
conduct is
eh,
kind of a cheer, but
kind of a
intended
jeer.
loss is definitely a jeer. So let's get to Zippo,
Yes.
because
Yeah,
this is a
Zippo. So
big
listen,
fucking jeer.
this is there's not an amendment that went into effect that we've been talking more about and doing more with than the Zippo that went into effect on November 1st. It becomes retroactive on February 1st, the 0 point offender amendment. But it's kind of a sad statement that the commission already has cause to revisit the language and clean up an alleged mess that they made, which we don't think is such a mess. But
It's not a
what's
mess at
going on?
all.
Yeah, so there's what they call a technical amendment to 4C 1.1, and it really revolves around this very big real issue about leader organizer enhancements. If you got a leader organizer enhancement originally in the guidelines, do you still qualify for the Zippo?
Yeah.
What's
So here's
happened
okay.
here?
So here's what happened. When the Zippo passed, the 0 point offender downward adjustment gave you two levels, a two-level reduction if you met 10 criteria. One of those criteria, the most important one, is that you had 0 criminal history points.
Yeah,
So
right.
this isn't a first offender adjustment, it's a 0 point offender. So you may have had some criminal history in the past, but it wasn't scorable in your PSR. So 0 points was the most important. But then they had a list of an additional 9 criteria, and these were exclusionary criteria. In other
Yeah.
words, criteria that would preclude you from receiving this adjustment, even if you had 0 criminal history points, such as getting the terrorism adjustment, or as we spoke about a little earlier, a violent offense.
Yeah.
Or like if you committed a fraud,
Yeah.
that you specifically, you the defendant, specifically caused substantial financial hardship to a victim or something along those lines. All those are well and good. You understand those. And this supposedly was empirically based, by the way. The reason why the commission decided to create this adjustment is they went back and they looked at those defendants that received 0 criminal history points versus those that received a single criminal history point. And they noticed something significant in the recidivism rates. The recidivism being the rate of reoffense after you complete your sentence. And the recidivism rate was significantly higher for those just with a single criminal history point than those with 0. But under the guidelines, they were treated the same for purposes of sentencing. Both if you had 0 criminal history points or 1, you're in criminal history category 1. So the commission, to its credit, did an excellent thing. One of the rare things it actually is supposed to do, is look at the data and make an adjustment to the guidelines. And so they looked at the data and said, hey, these guys with 0 criminal history points don't recidivate very often, very rarely, as a matter of fact. And we don't make an adjustment for that right now under the guidelines. So we're going to give them an additional 2 levels off. But for policy reasons and blah, 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 we're going to add some additional criteria. It's just not going to be anybody with 0 criminal history points. They can't be a terrorist, no violent offense, and all the other stuff I spoke about. But this came down to criterion 10, which you and I had a podcast about.
Yes.
And
By the way,
10,
episode 72 called Imperfect 10, Why Thousands Could Lose Zippo Eligibility.
Right.
Yes.
And I'm pretty sure my friends at the Sentencing Commission watched
and listened to
this.
No. Well, that's heartbreaking.
Well, no, it's not heartbreaking, but they just came up with the wrong damn conclusion. And I explained to them right now why.
Part. Yeah.
It is the heartbreaking part. But the good part is this hasn't gone into effect yet. This is just a proposal that I'm getting to. And I want everybody listening and watching to write to the commission and say, don't do what I'm going to review with you right now.
Yes. Okay. And we'll put some links in the show notes of the website and don't just write to the commission. I think you could probably write to your congressperson, your senator, like that, like write to anybody who can. But so what do we write about? What's the argument?
So here's what the 10th criterion under the 0-point offender, what it said was that if you have a role in the offense adjustment under 3B 1.1, which already means you've generally been convicted of a conspiracy, so you were a supervisor, manager, or leader in this conspiracy, and you were engaged in a continuing criminal enterprise, then you were ineligible for the 0-point offender enhancement. Now, that and part, many people focused on. So you got to have both to be excluded or one to be excluded.
Yeah.
I understand why people went down that road. It was irrelevant. The real issue is, where did that language come from? Just instead of doing a logical analysis, which is very weird for me since I used to teach logic, to poo-poo the logic here. But to do the, if you were the statutory history behind this particular criterion, look at the language. Where did that language come from? You can't have a role in the adjustment offense, and you can't have engaged in a continuing criminal enterprise. It came from what we spoke about earlier, the safety valve.
Mm-hmm.
And that is actually one of the criteria for the safety valve, is that you can't have a role in the adjustment and have engaged in a continuing criminal enterprise. Courts across the country have interpreted that language to mean what it really means. It's not apparent from its face to lay people, but what it means is, if you are a manager in a drug conspiracy, an ongoing drug conspiracy, that's what the continuing criminal enterprise means by definition.
By definition, right.
And that's what the statute for the continuing criminal enterprise pertains to, is that you're a manager in an ongoing drug conspiracy.
Yeah.
Okay. You're not the mule. And
right.
This is what the courts have said, interpreted that language to mean. It's that it's to allow mules to still receive the sentencing valve. It's only meant to preclude management level individuals in a drug conspiracy from receiving the sentencing valve. And that's almost verbatim, with a few immaterial changes. The commission took that language, and it says this. It says in the reason for the amendment for 4C 1.1, they referred to the safety valve. It took that language and put it as criterion 10 for 4C 1.1. So what does that mean? It means that if your management, so you can't have committed terrorism, it can't be a violent offense, it can't be a sex offense, you can't have caused substantial financial hardship to a victim, and you could not have been a management level individual in a drug conspiracy,
in a continuing criminal,
continuing criminal enterprise,
right.
And
which
so that makes sense.
Yes, which meant
go ahead.
That everybody and lots of people get a leader organizer enhancement in a regular old crime of 2, 3, or 4 levels, and people presume that they were going to be ineligible under criterion 10, but under that reading, no, they are not. They're absolutely eligible.
Right. So under the reading that I'm proposing here, so if a fraud defendant, if a money laundering defendant, if a tax defendant, antitrust defendant, even not child pornography, won't work, sex offense, but any of those defendants, generally in economic crimes, if they received a role adjustment, they still would be eligible for the 0-point offender downward adjustment. Just because, and the reason why, again, is because their role adjustment was not in conjunction with the continuing criminal enterprise.
Right.
So the commission listened to us
and said, "Oh, we fucked that up. Let's fix it."
No, I know this was an example of something that didn't need to be fixed, because it made perfect sense, because it was all about precluding recidivists. You don't want to that's why you go with the 0 points.
Right. Well, you in a perfect world, there's no need to fix it. But clearly,
Exactly.
because they're proposing to bifurcate these things out and create a criterion 11 that just deals with leader organizer, the
Right.
commission, for some odd reason, says no, we need to now exclude leader or organizers for any kind of crime from this two-level reduction. That's what they're proposing.
Well, this is what they're proposing. Folks, this is stupid.
Asinine.
It's asinine, it is stupid.
We must
And it
stop it.
doesn't, it really, it's not going to alleviate all the confusion, because if they just want to get, and by the way, here's what you're looking at right now on the screen. I have criterion 10 and the new proposed 11.
Yeah.
All the proposed criterion 11 is just they're breaking out the second conjunct from criterion 10.
The continuing criminal enterprise.
The continuing criminal enterprise. But hello, to be convicted of a continuing criminal enterprise, you must be a manager of a drug conspiracy. You already have that 3B 1.1 aggravating role adjustment. So there's no need for this criterion 11. If they just want to exclude anybody that received a role adjustment, then all they needed to do is get rid of any reference to the continuing criminal enterprise. It makes no sense while they're keeping it in.
You're saying that if you look at the definition under 21 USC 848 of continuing criminal enterprise, that leader organizer role is baked into the cake of the elements of that definition.
Yes, 21 USC 848 C2A. This is the definition of what a continuing criminal enterprise is. And one of the elements is that the defendant undertook in concert with 5 or more other persons with respect to whom such person occupies a position of organizer, a supervisory position or supervisory position, and any other position of management. That's all baked, to use your terminology, baked in to the whole definition of a continuing criminal enterprise. You already have to have that. So it's redundant. So they kept a redundancy in there. If the commission, and I'll put it this way again, if the commission wanted to say that nobody who receives a 3B 1.1 role adjustment is eligible for the Zippo, then they should have left the any reference to the continuing criminal enterprise out. They should have just said, you get a 3B 1.1, you don't get it, period. That's it. Now, here's why that's stupid, though. I mean, not only is it stupid to keep in criterion 11, the continuing criminal enterprise, but it doesn't make any sense, because there is zero empirical evidence that just because you got a +2, +3, or +4 as part of a conspiracy, and you otherwise are eligible for the 0-point offender, that your risk of recidivism is any higher than any other 0-point offender. There's zero, and they cite to none. But that was the whole point of the 0-point offender adjustment, was it was supposed to be empirically based, data-based. Exactly. And so it makes sense why you would put in this this criteria from the safety valve. Because these people, by definition, would be recidivists, because you have to commit it several times. If you look at let's see, if you look at 848 again, let's look at the continuing criminal enterprise definition. Down here at C, you have to have a continuing series of violations. Right there, continuing series of violations. That's recidivism. So so that makes sense. But if they're trying to get rid of that prong, then they should have gotten rid of it per se and not kept it in at 11, because it's still going to create confusion. And it doesn't make any sense from a policy perspective, because it's not empirically supported if they just want to get rid of if they want to preclude
Okay.
anybody that had a
All right.
3B1.1.
So
Okay,
so
that's my
here's
TED talk.
that's a great, I mean, it's important to break it down like that because
Yeah,
we can see how absurd it is. But
right,
there are real good reasons why we need to reach out and convince them that this is bad policy and this is that they need to leave your continuing criminal enterprise. Super. Get rid of this leader organizer. You mentioned one. There's no
yeah,
empirical data to support this.
correct,
It's irrelevant to the
correct,
idea of recidivism, which is the whole
correct,
point of this.
right.
Two, I'm worried that the AUSA, the government, who has way too much power in this process in general, and in particular in plea negotiations, is going to use the leader organizer enhancement as a cudgel to beat the shit
Yes,
out of our clients in plea negotiations, which is to say,
correct,
we don't want them to get the extra 2 levels. We know they have zero criminal history, but we don't like this person and we think they're really bad. And so we don't want them to get 2 levels for the Zippo. And the way that we can avoid them getting the 2 levels is if we force them to stipulate that they're a leader organizer. And so then you've got a situation where you're getting manipulated into a stipulating to a leader organizer enhancement that then deprives you of the 2 levels. So not
correct.
only are you not getting the 2 levels, you're getting an extra 2, 3, or 4. So you could end up
Right,
6 levels higher than
right.
you would have been if the prosecutor didn't try to manipulate that out of the plea agreement.
One thing though that I will add though, in a situation like this, and you're for whatever reason you're hamstrung in or you're strong armed into a plea agreement where you have to stipulate to the
Yeah.
3B1.1 adjustment
I know what you're gonna say.
variance.
Plead open. No, I thought you were gonna say plead
Oh,
open.
well, either plead
Then you don't
open,
have to stipulate to any of
right?
that bullshit.
Exactly. Either plead open, and that's
Yeah.
perfect. Yes.
Yeah.
And, yeah. So you might pleading open might cost your client $100 in the special assessment,
Yeah.
or a couple $100 at most,
Yeah.
literally,
Yeah.
or and if that's not viable, then argue for a variance on this ground
Yeah. Yeah.
and just say, look, yeah, okay, Judge, he got the adjustment, but it makes no sense why he shouldn't receive the 0 point offender adjustment. Yes, you technically can't give the -2, but you can vary by at least two
Yeah.
levels. And
The
that's what I do in this
the
case.
other reason why I don't like this is, you know, there are so many people sitting in prison right now who otherwise would be completely deserving and worthy of the retroactive application of the Zippo, but
Right,
for they got a leader organizer way back in the past. No lawyer was realizing the implications of that, couldn't
right,
have predicted how
right,
badly that would hurt their client in the future. Maybe
right.
they didn't litigate it, they didn't fight it that hard, whatever, but they do kind of hand this enhancement out pretty frequently. I don't
Well,
want to say
so
like
yeah, right.
candy.
They do know it's around, I think, around a third
So
of the time right now across the board.
okay, so that's a
Um,
lot. That's a
yeah, it's a
lot.
lot.
I didn't
Yeah,
know that.
we're talking around
Missed
25,000
Leave it
cases
to
a
you
year.
to have the data. So so this is the thing. This is not in effect. Everybody needs to understand. This is not a done deal. This is
Right.
a proposed thing, and we can stop it with our well-reasoned, impassioned pleas to the right people. And so everybody, I encourage everybody to reach out and offer their commentary to the Sentencing Commission. Again, we'll put some links
Yes.
in the notes, to maybe summarize some of the more salient arguments, but to stand up and be heard. Lawyers definitely. Clients, loved ones, people who have clients in prison right now who are dying for that retroactive application come February 1.
Do it now. Do
Do
it
it
now
now,
before the
man.
commission screws it up. Yeah.
Yeah, because right now the criterion 10 is what it is, and you've got a
It
valid legal argument.
boom.
And so right now the law is on our side. So
Yes.
don't let this discourage you from making that
Yeah.
argument. But we
For
got it.
retroactive application and going
Yes.
forward, because this proposed change, if it goes through, will not take effect until November 1, 2024. So you got about a year.
Yeah.
Yeah.
Yeah. Yep. And don't let them make the argument to say, well, this is what the commission intended. Look at the proposed changes. They're misguided, and we're
Yeah,
going
they're
to show them
misguided. They're
the
doing
error
it
of their
wrong.
ways.
Yes. Right.
And we can
Eh,
do that. And I have hope.
Yes.
I have hope for that. But in any case, I think it's time to land this plane. And I
Yeah.
will say to you, may yours and everyone's wildest dreams come true for 2024. We
Thank
will
you,
be back.
Pedro. Thank you.
Vote for
Vote for
Pedro.
Pedro. Yes.
Happy New Year, brother.
Hey, Happy New Year. Xing Nian Kuai Le. You're the dragon.
You're the dragon.
Yep.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.